This is Colin O'Keefe for LXBN TV. The governor of Massachusetts is backing a bill that would make non-compete agreements a thing of the past in the Bay State. Joining me now from Boston to discuss what this would mean for Massachusetts employers is attorney Dawn Mertineit. She is with Seyfarth Shaw, an author on the firm's blog, Trading Secrets. Dawn, first, what can you tell me about the basics of this proposed piece of legislation? Does it really mean that non-compete agreements would really no longer be necessary there in Massachusetts?
Well, the bill does eliminate nearly all employee non-competes, and certainly proponents of the bill have suggested that the adoption of the Uniform Trade Secret Act should really ease any employers who are concerned about the elimination of non-compete agreements. Obviously, critics disagree. The critics of the bill have made a couple of points suggesting that the adoption of the Uniform Trade Secret Act don't do enough, and there's a couple of reasons for that. First and foremost, in Massachusetts, non-compete agreements are used not just for trade secrets, but also to protect an employer's goodwill with its customers. So the mere adoption of the Uniform Trade Secret Act doesn't necessarily protect employers to the same extent. The other issue, of course, is that proving, especially at the preliminary injunction phase, a likelihood of success on the merits of a trade secret misappropriation claim is a lot harder to do than proving the likelihood of success on the merits of a breach of contract claim. So it's going to be very difficult for employers to protect their confidential information, goodwill, other legitimate business interests, and that's going to change their litigation strategy.
I see. And then second, though this is just a bill with a long ways to go, what should employers with Massachusetts employees do to prepare for the potential that this does eventually become a law?
Well, there are a lot of things that we would recommend, and this is even if the bill isn't passed. There are lots of things that employers can be doing and should be doing even if they do have non-competes that are enforceable. One easy thing to do is to make sure that access to trade secrets and confidential information is truly limited to those employees who absolutely need access to those documents. Another thing to do is to make sure that employers have really good entrance and exit protocols. So as an employee is coming in, you make them understand that the company takes confidentiality very seriously. You provide them with a copy of a confidentiality policy, and you explain the sorts of information that the company considers confidential. On the other side, when an employee is leaving, you want to make sure that you've reminded them of their obligation to maintain the confidentiality of the company's sensitive information. You also want to maybe check that employee's computer activities in the last couple of weeks of their employment. Make sure they're not emailing things to themselves, making sure that they're not plugging USB drives into their computer at an alarming rate, and make sure that you're getting all the documents that they may have received and accumulated over the year, whether for good reasons or for bad reasons, you're getting all of those back. But it shouldn't just be a bookend. You want to make sure that throughout your employees' employment, they understand that the company takes confidentiality seriously. Another thing that employers can do is to make sure they have non-solicit agreements. This bill does not affect non-solicit agreements. So if you want to make sure that your employees, as they depart, have some limitations on which customers of your client they can reach out to, that's something that can help protect the employer's interest. And finally, one thing that I can't stress enough, employers should really be focusing on new technology and what it means for employees to share confidential information. 10 years ago, we weren't talking about dissemination of trade secrets on social media. 10 years ago, we weren't talking about trade secret misappropriation by accessing documents on the cloud. We're talking about that today. So employers really need to think about whether they need to have new policies, a social media policy, or whatever is going to come in the next 5 or 10 years. Make sure they're updating their handbooks so that employees understand that they can't disseminate trade secrets or confidential information in those ways.
Absolutely. With new technology coming out, it absolutely pays for employers to be proactive on this front. Once again, that was attorney Dawn Mertineit. She is again with Seyfarth Shaw. And for more of her insight on this topic and others related to it, be sure to visit tradesecretslaw.com. Thank you for joining me today, Dawn.
Thanks, Colin.